Thank you very much indeed, Josh. Our final presentation this evening will be from Richard Padley, who is going to speak about the use of psychiatric evidence in criminal trials. Richard.
Thank you very much, Andrew, and good afternoon, ladies and gentlemen, and thank you for joining me in this short webinar on the use of psychiatric evidence in criminal proceedings. What I hope we'll discuss over the next 20 minutes or so is a bit of background in relation to expert evidence in general, and then go on to really discuss what's at the heart of this webinar, which is some of the use of psychiatric evidence and where you'll come across it. So Andrew, first slide, please. What is expert evidence? Well, experts hold a special place in the criminal justice system. Unlike ordinary witnesses of fact, they aren't there because of where they were at a particular time or date. They're brought into the proceedings because of what they know. So it's quite important when we bring in an expert that we've done due diligence on them, we know about their qualifications and their background, because they aren't just giving evidence about what facts are within their knowledge, but also what their facts means. They give opinion evidence. And we come across that quote in the South Australian case of Bonathan, given by the Chief Justice King, which is often referred to in a number of cases. Now, when people think of expert evidence, most people immediately go to the sciences or some sort of forensic analysis. DNA, gunshot residue are very common matters. But expert evidence isn't just based on the sciences. In a case called Ahmed, back in 2011, an expert was able to give evidence about the historical facts of Al-Qaeda. In fact, in a civil case, Berezovsky and Hine, the political and economic situation in Russia was the topic of expert evidence. So a broad range of matters fall within the qualification of expertise that the court will listen to. So who is an expert? Well, an expert is an individual who has specialist knowledge in a particular area. That specialist knowledge can either be gained through a number of years of study or experience. And from the outset, a bit of practical advice. When considering an expert report, it's very important that the expert is given that information as full and as thorough as possible. And that's particularly so if they're giving evaluative evidence, trying to put some form of statistic on the likelihood of a proposition being made. But that's outside the scope of this seminar. The formalities of an expert report can be found in Rule 19.4 of the Criminal Procedure Rules. It's important that they are followed because a lack of compliance with those headings, with those various things that need to be presented, could result in your expert's report being excluded as evidence, and that's not what we want. Very briefly, final matter on this slide. Presenting expert evidence and some of the things to consider. Firstly, Section 30 of the Criminal Justice Act 1988, that allows the report to go before the jury, even if the expert isn't in court. It effectively allows the party that's seeking to present the expert evidence to adduce this as hearsay evidence. But of course, the court won't do that easily, and arguments will have to be raised as to the risk of potential unfairness to the other side. And they, of course, could be great given the nature of the material. The other important thing to think about with an application under Section 30 is whether what you've got or what you're faced with is in fact an expert report. Because if the prosecution is simply providing an SFR1, and we're seeing more and more of those in proceedings these days, that isn't an expert report. It doesn't fulfill the criteria of Criminal Procedure Rules 19.4. So if that's what they seek to get before the court opposes. Section 127 of the Criminal Justice Act 2003 allows an expert to rely wholly on the preparatory work that underlies their opinion without actually formally adducing that underlying work into evidence. Now, a common area where we see that is in the topic of DNA, where inevitably the person that's taking the stand is the forensic scientist. They are the ones giving the evidence, but ultimately they're not the only people that have done the work on the case. Section 127 allows that to happen. that the underlying statements from the scientists and the assistants that have helped with the work don't need to be formally adduced into evidence. Additionally, in terms of how the evidence is presented to the trier of fact, whether that's a magistrate or a jury, Crown and Metcalfe is the last of a long-running history of cases that deals with presentations. Now, words are one thing, but you may think that actually it's easier to present expert evidence at times through the use of animations or diagrams or graphs, charts, tables, as long as that evidence forms part of the presentation of the expert evidence, rather than being something new or different or scientific. It can be used without a problem to present that evidence. Next slide, please, Andrew. So let's look at psychiatry, and let's look at the first topic, fitness to plead. Now, the fitness to plead procedure in one form or another is one that most practitioners will have come across during the course of their practice. Of course, it goes back to the case of Pritchard back in 1836, but that's been slightly fleshed out in modern times in the case of Crown and M. John 2003. And 6 key capacities were considered for whether a defendant was fit to plead or not. The ability to understand the charges, the ability to decide whether to plead guilty, the ability to exercise the right to challenge a juror, the capacity to instruct solicitors and counsel, the capacity to follow the course of the proceedings, and of course the capacity to give evidence in their defence. Where a psychiatrist considers that one or more of those factors are there, it provides an indication that the defendant is unfit to plead. But fitness to plead is a matter of procedure. It's a statement that the person that's being tried isn't mentally fit to do so. They don't understand what's going on. So it doesn't provide the defence with a defence to the proceedings. It simply slightly changes the way the proceedings are going to be held. Now, how the fitness to plead procedure is ultimately carried out depends on which court the matter is in. So let's deal firstly with the Crown Court. In the Crown Court, things are a little bit clearer. We have the Criminal Procedure Insanity Act 1964, which sets out the procedure for us. In terms of timing, the issue of fitness to plead should of course be determined as soon as it can do, as soon as the required information is before the court. But its determination can be postponed until any time before the opening of the defence case. If the issue is being raised during the trial, as it was in a 2016 case of Patrick Orr, then the judge may well adjourn the proceedings to allow for a psychiatric report to be obtained so that that issue can be addressed. Because any finding of unfitness, which is now done by the judge rather than the jury, can only be made up to the point where a jury return the verdict. So how is the issue determined? Well, determination of the issue requires the written or oral evidence of 2 or more registered medical practitioners, at least one of whom has to be what's known as duly approved. An approved practitioner is one who's approved by the Secretary of State as a practitioner who has experience in the diagnosis and treatment of mental health disorders. And they are approved under section 12(2) of the Mental Health Act 1983. Now, following discussions between the experts, between the psychiatrists, if there remains an irresolvable issue between the prosecution and the defence over the issue of fitness to plead, that will be determined by way of a contested oral hearing. Now, it's not envisaged that at that hearing, the defendant themselves will have to give evidence, but there's no rule against this. Generally, it will be a battle of experts to see who comes out on top. It's not the case, even if all experts agree that a defendant is or isn't fit to plead, that the judge, of course, has to accept the recommendations of the psychiatrists. It's ultimately for the judge to consider, taking into account that evidence, whether or not they agree that the defendant is unfit to plead. And factors outside the report of the psychiatrist including matters of their age, IQ, for example, may well be thrown into the mix. Who bears the burden and the standard of proof of proving it? Well, it depends on who raises the issue. If the issue is raised by the prosecution, it's for them to prove that the defendant is unfit to the criminal standard. But where the issue is raised by the defence, it's for them to prove to the civil standard. Where, independently of both parties, it's raised by the court, it's the prosecution that have to prove that the defendant is fit to plead, again, to the criminal standard. But what happens afterwards? What happens after this finding of an unfitness to plead? Well, the procedure that's then followed is found in section 4A, again, of the Criminal Procedure Insanity Act 1964. Where a defendant is found to be unfit to plead, they won't face trial, but instead the jury will determine whether or not the act or the omission that's alleged has been conducted. On that basis, any evidence will be presented by the prosecution, and ultimately the jury will have to come back with a decision. Did they do the act or omission alleged, or did they not? That's known as a process as a trial of facts. And the jury will have to consider that to the normal criminal standard. The position is slightly different in the Magistrates' Court. It's not the 1964 Act that we look at. Instead, it's the Mental Health Act 1983, section 37.3, and the Powers of Criminal Court Sentencing Act 2000, section 11. Dealing first with section 11, that allows the Magistrates' Court to conduct an inquiry into the mental state of a defendant upon finding that facts have been proven. Section 37.3, which is read in conjunction, provides that where a court finds that a person is suitable for a hospital order, they can make that order upon finding facts of an offence, but without formally convicting the defendant. So it's the combination of those two pieces of legislation in the Magistrates' Court that provides an equivalent of the fitness to plead procedure that we see in the Crown Court. Now, as with the Crown Court, 2 medical practitioners will be required to be able to raise and prove this issue and deal with it by way of a hospital order or other form of appropriate disposal. If the court finds that they're satisfied that the defendant is in fact suffering from a mental disorder, they can go on and impose that hospital order. If, however, things are a little bit more serious and a section 41 order is required, the Magistrates' Court can commit the matter to the Crown Court by virtue of section 43 of the Mental Health Act 1983. Andrew, next slide, please. So what powers do the courts have to remand an individual, whether on bail or in custody, for the purposes of assisting in getting this psychiatric report? Well, in the Magistrates' Court, section 11 of the Powers of Criminal Court Sentencing Act allows the court to adjourn the case for consideration of the defendant's fitness, either remanding on bail, or 3 weeks if in custody, 4 weeks if out on bail. But if they are on bail, the condition will be imposed that they undergo a medical examination, or where the court directs examination by 2 medical practitioners. The alternative power to assist in producing this evidence is found in section 35 of the Mental Health Act 1983. Now that allows either the Crown Court or the Magistrates' Court to remand a defendant to a hospital for the purposes of completing the report on the mental health of the defendant. In relation to the Crown Court proceedings, the section allows for the remand of any person who has been arraigned but not yet been sentenced. In the Magistrates' Court, the section can be used for any person convicted of an offence punishable by imprisonment, and any person who the court is satisfied did the act or made the omission. Now, when the court is exercising these powers, it must receive the written or oral evidence of a registered medical practitioner, giving reasons to suspect the accused person is suffering from a mental disorder, and importantly, that a place is actually available for the accused's admission to hospital. If it works out there's not a place available, in a hospital for the person to go, then the remand has to come back to court to be dealt with in another way. A remand under section 35 can only be done for a period of 28 days at a time, but it can be extended upon a further report saying what progress has been made. But that can only be done for a maximum of 12 weeks. Next slide, please, Andrew. Insanity, another topic involving psychiatric evidence. Well, insanity, unlike fitness to plead, is a complete defence to the proceedings, and it allows for an acquittal to be registered. Insanity, of course, goes back to a case of Daniel Manarton, who assassinated a civil servant while suffering from paranoid schizophrenia. And a set of rules were outlined in that quote that's on the slide, outlining what is required to be met for the purposes of insanity. And actually 180 odd years later, we're still very much looking back at that case as being the cornerstone of this defence. But what does it mean? Well, if the defendant was ill and such that they didn't know what they were doing at the time of the act, or that they were aware that they were doing, but they weren't aware that what they were doing was in fact wrong, they have this defence open to them. In respect of the latter part of that, this isn't someone that simply doesn't know that murder is illegal, but someone who, for example, believes that they're shooting a demon or some other thing rather than an actual person. So they know that what they're doing is murdering something, but they don't know that they're murdering a person. It's for the defendant to prove on the balance of probabilities that they are in fact insane within the test. And where the test is satisfied, the defendant will be found not guilty by reason of insanity. Now that's known as a special verdict, and that's one that can only be decided by a jury. Where a special verdict is reached, the court will dispose of the defendant in one of three ways as set out in section 5 of the Criminal Procedure Insanity Act 1964, and we'll come back to that very shortly. Now, in the Magistrates' Court, whilst there's no procedure for the special verdict, it does remain a common law defence which can be raised. The court will then go on to consider whether it's appropriate to pass a hospital order under section 37(3) of the Mental Health Act 1983, if it considers it appropriate to do so. Now, although there's no requirement in law to put expert evidence before the jury in order to reach that special verdict, or the same in the Magistrates' Court, you might think it might be a little bit odd if the court didn't at any point hear any psychiatric evidence in reaching their final decision. Andrew, final slide, please. Very quickly, disposal of cases in relation to matters of fitness to plead and insanity. And let's come back to that section 5. Section 5 of the Criminal Procedure Insanity Act provides that where someone is found unfit to plead, the case can be dealt with in three ways: a hospital order with or without restrictions, a supervision order, or an absolute discharge can be passed. And those three consequences, those three disposals, are also available to the court where a finding of insanity has been found. Now, section 37 of the Mental Health Act 1983 provides that the court can issue a hospital order. To do so, it must have received the evidence of 2 medical practitioners and be satisfied that the defendant is suffering from a mental disorder. In practice, of course, they may well likely be the same practitioners that has assisted the parties throughout the course of the proceedings, and it's simply a matter of updating their report to deal with the disposal of the case. Again, one of those practitioners has to be an approved clinician in accordance with section 12 of the 83 Mental Health Act. But where the psychiatrists recommend a hospital order under section 37, the court remains under an obligation to carefully consider all of the evidence to determine whether the hospital order is the most suitable disposal. And in considering that, it will look at to what extent the offender needs treatment, the extent to which the offending is attributable to the mental disorder, and the extent to which some sort of punishment other than a hospital treatment is required. And that's really where this section 45A Mental Health 1983 Act order will come into force, because it's known as a hybrid order. And a hybrid order combines the hospital part of section 37 with a period of time in prison, determined on the facts of the individual case, taking into account the length of time that it's considered will be needed to treat the defendant. Now, in terms of how the court goes about a section 45A order, it will first consider whether there needs to be a penal element, and if not, if the circumstances of the particular case don't require that, or that the emphasis should be on treatment, it will then move on to consider section 37. Now, where a section 37 order has been made, the defendant has to remain at the hospital until they're assessed as mentally sound to be released. The person can apply to the mental health tribunal to discharge the order, and the tribunal will consider whether they're no longer suffering from that mental disorder that justifies their detention in hospital. By contrast, of course, we have that section 45A hybrid order, which is where the person has been released from hospital. They will then move towards a period of imprisonment. Section 41 orders, almost there, is effectively a tag on to the section 37 order, and a section 41 order is indefinite. It's not limited by time, unlike the section 37 order. Dealing through some of the other disposals that are available, a supervision order requires a person to be supervised by a social worker, a probation board officer, for no more than a period of 2 years. It's not to be assumed that the person that's supervising the individual is actually going to be prepared to do so. So when this type of order is being considered, it's important to get the approval of the person who is going to be supervising them. A guardianship order available in a magistrate's court, where a court has made a decision to dispose of the defendant without actually convicting them under section 37(3, imposed on a person who's at least 16 years old, and they'll be cared for in the community. As the name of the order suggests, a person subject to a guardianship order requires that a person can reside at a particular address under the care of their guardian. They are to attend at places and times so specified for the purpose of receiving medical treatment, and the power to access the patient can be given by the courts for any medical practitioner if they need to see them. Finally, let's look at mental health treatment requirements. The power to pass one of those is section 207 of the 2003 Criminal Justice Act, and that will be attached to either a community order or a suspended sentence. It requires that the offender submit during a period of treatment to a period of treatment, even by a registered medical practitioner. Either that can take place either at a care home or a hospital, and they can be treated as a non-resident patient, or they can be treated under the direction of a medical practitioner or a psychiatrist. But to do so, the court must be satisfied that the mental health is an issue, that it can be treated, and that the offender has expressed willingness to comply with the order. Well, I hope you found that helpful. That concludes this talk, and I hope you're all keeping well. Thank you.